for the interest, in the best interest of their children. They want to not drag each other through court, they want to get this behind them, then negotiation might indeed work. It probably doesn't work all that often if all you have are the two parties talking to each other. It's probably more helpful to have an advocate, like a lawyer on each side, but then when you get lawyers involved, oh my God, who knows what happens, right? So negotiation, it's out there, but it's not really all that effective. Mediation is more effective because mediation involves a neutral third party. You have one party here, the other party here, and in the middle, you have the mediator. Mediator means in between or in the middle, right? So this person is a person that the two parties have agreed upon, first of all. They both agree on who the mediator should be. And the mediator is going to be, in all cases, a neutral third party, who basically, the process works kind of like negotiation. The mediator sets a date for the mediation. Everybody shows up. Usually this is held at one of the lawyer's offices, or if the mediator has an office, you can go there. Everybody gets in the same conference room. The mediator, who's going to preside over this little proceeding, says to the plaintiff, or the person who's going to be the plaintiff, and you can do this, by the way, even when you're in the middle of a lawsuit. You can still do mediation. But the mediator says, all right, tell me your side of the story. Usually that's the lawyer for that party talking, laying out the case. They usually give you 5 minutes or so. Then the mediator says to the other side, tell me your side of the story. Once the mediator has heard both sides of the story, he separates the two groups into separate conference rooms. And the mediator's job is then to go back and forth between these two parties, telling each one of them why their side of the case sucks. And they need to get real. And the plaintiff needs to come way down in the money she says she wants, and the defendant needs to come way up from the money the defendant says he's willing to pay, right? So what the mediator does, the mediator is usually somebody who is knowledgeable about the law in the area, and then of course mediators and arbitrators are often lawyers, but they don't have to be, but it kind of helps because the law comes into play. How you convince a party that their side of the case is really awful and they're not going to win if they insist on going to trial is to tell them, these are the facts as I appreciate it, and this is the law. And under the law that applies to your facts, you ain't going to win. You ain't going to get the kind of money you're talking about. And you're going to get nailed for a hell of a lot more money than you think you are. If you want to go to a jury, go ahead. Go take your chances, right? So the mediator plays them off, one against the other, and just tries to tell both sides why they need to lower their expectations and be reasonable, that a good resolution of any dispute is a resolution where both parties go away a little bit unhappy, because that means compromise, right? They gave up something they wanted. Compromise is the key to mediation. Unfortunately, the mediator has no power to force the parties to do anything. So if the parties don't agree to a resolution, then nothing happens. Now, y'all saw the multiple choice questions, I put them up on Moodle for you. So there is one question in chapter 3 in the study guide that I will not put on the test. And that is, there's a question there that says, the mediator can only, and the study guide says the correct answer is that the mediator can only impose a resolution that the parties have previously agreed to. I don't agree with that. In this sense, if they can agree to a resolution ahead of time, what do you need the mediator for? I don't know what that means. In my experience with mediation, the parties don't agree to anything ahead of time. They simply have the mediator there to help them see if they can work out the dispute. So that question won't be on the test because I don't want to confuse you all. I have a different view than the writer of the question did. Yes, ma'am.
So that's the question with Fleet Feet Incorporated?
I don't know. Read the question.
That company sells to-go sports goods. They agree to mediate the dispute. Though does not mediate and dictate, the mediator can impose.
That's correct. I think the correct answer to that question is, can impose no resolution, no remedy. Your book says, well, only a remedy that the parties have previously agreed to, but that's stupid, because I think you can agree to a resolution, what the hell do you need to go to a mediation for? Mediations can, some of them, like big cases, like construction cases, where you got 15 subcontractors and suppliers, like, screaming at the general contractor, we haven't been paid, we want our money. Mediations can take 3 days, 4 days, 3 weeks, and they cost money, because you gotta be able to, like, show the mediator your evidence and everything, right? So, I think, so that question won't be on, but you should nevertheless know how mediation works and what it is. So finally, we come to arbitration. Arbitration is big, big, big money in the United States and really internationally now. So arbitration also involves a neutral third party, referred to as the arbitrator. The big difference, however, is an arbitrator is going to decide the case. The arbitrator has the power to say, you win, you lose, or you lose, you win, or I'm splitting the baby. You get a little something, you get a little something. The arbitrator, in other words, functions really just like a judge in a case. And arbitration itself is more similar to a trial than mediation or negotiation by a long shot. So here's how arbitration works. The person who wants to get the ball rolling files what's called a demand for arbitration. But you don't file it in a court, because you ain't going to court, right? This is an alternative to a court. So you file with some sort of arbitration service. The biggest company in the U.S., and probably internationally, who handles arbitrations is called the American Arbitration Association. So you can go online to their website, and you can download and print a document, a form called Demand for Arbitration. The person fills it out, says, this is what my dispute is about, this is how much money I want, this is the defendant, the other party, sign off on it, send it back to the AAA. AAA then sends the demand for arbitration on to the other party, the person you're basically trying to get your money from. Once that happens, the AAA will send out to both sides a list of possible arbitrators. And the way it works is both parties have to agree before anybody on that list will be appointed as the arbitrator. So usually the list of arbitrators is going to be, as I said, most often lawyers, and it's going to be lawyers with expertise in the subject matter area that the arbitration is going to be about. So if it's a construction thing, the arbitrators are all going to be construction lawyers, right? Or they're going to be non-lawyers who have an enormous amount of experience in construction and paying claims and all of that kind of stuff. So the arbitrator, by definition, has to be knowledgeable about the law and the subject matter of the case. So when both parties can agree, usually you'll get a list of maybe 10, 12, 15 people. Both parties agree on who the arbitrator is. They notify the AAA. AAA acts as the go-between through the entire process, because that's how they make their money, right? You pay the AAA fees for handling all this. So AAA then notifies the arbitrator who's been selected and says, you've been asked to be the arbitrator in this case. The arbitrator is then asked to fill out a disclosure form indicating, is there anything that would keep this arbitrator from being able to be fair and impartial to both sides? Like, is the defendant your brother-in-law? Or is the defendant your former law partner? Or what connection does this arbitrator have, if any, to any of the parties? And he's got to divulge that. Sometimes they divulge it and both parties go, yeah, it's fine, it's okay, I know he's a fair guy, it's fine. But if they don't, if he gets thrown out because one of the parties objects to something he's disclosed, then you go back to the list and they have to pick another arbitrator. Once that's done, administered, as I said, still by the AAA, but it really kind of works like a trial. So in arbitration, the parties can exchange written discovery, interrogatories, requests for production of documents. You can take depositions of the other side's witnesses if you want to. You can file motions for summary judgment. You do all the same stuff you do in court, but you're not doing it in court in front of a judge in a black robe. You're doing it through the AAA to an arbitrator. Everything will be sent to the arbitrator by the AAA. And the arbitrator will send his rulings to the AAA, and they'll be sent out to the parties. So the AAA stands between the arbitrator and the parties, so nobody can browbeat the arbitrator or harass him or any of that kind of stuff. When the day and time arrives for the arbitration hearing, and again, that can be 1 day, a half a day, or 2 months, depends on what's involved. The arbitrator shows up, the parties show up with their lawyers, their witnesses, their documents, and basically the arbitrator just acts like the judge would at a trial with these couple of exceptions. Arbitrators often will say to the parties at an arbitration hearing, all right, to the lawyers for both sides, y'all don't have to make objections like you do in court. In court, if the other side asks a question that you object to, that you don't like, but you don't make an objection on the record, then if you lose the case and you want to appeal it, you can't argue that because you didn't object to it at trial, right? So you gotta constantly be, on the tip of your brain, aware of everything, because if you don't make the objection at trial, you can't raise that on appeal later on saying, well, the judge shouldn't have let that evidence in. Well, did you object when he let it in? No. Well, then shut up. You can't complain about it now. But in arbitration, the arbitrators know all that, so they relax the rules of evidence, and they say, y'all don't have to make objections. It's just going to slow the whole process down. I know what good evidence is, and I know what bad evidence is. You don't have to object. I'm going to let everything come in. I'm going to let every witness testify who wants to testify. I'm going to let every document come in. And then, when the arbitration hearing is over and I have to rule, I have to make a decision, I know what evidence I can rely on and what evidence that I have to ignore. Because the rules of evidence apply, but the arbitrator has to know them, but instead of taking time during the hearing to rule on every objection and every document, he says, I'm going to do that on the back end, okay? I won't issue a decision that relies on bad evidence. Trust me, I know what I'm doing. One of the other things you need to know, an arbitrator's decision is referred to as an award. The arbitrator's award. That's not a judgment, that's not a verdict, it's an award. However, the winning party has to take the arbitrator's award and go to court and get the judge to do his little mojo blessing over the award and turn it into a judgment, if you want to be able to collect on it, just like the other judgments. So why do people arbitrate? What's the advantage of arbitration if it's just like a trial? Well, the advantage of arbitration is supposed to be it moves much more quickly than a trial would. It's less formal. Again, the rules of evidence are relaxed. It's not, yes, Your Honor, no, Your Honor. You don't have to be as formal about it. And it's supposed to be, or used to be, cheaper. That's not really the case much anymore. Arbitrations can end up costing almost as much as trials do. Because expert witnesses and depositions and all that good stuff come into play in an arbitration. So you need to make sure you look at Chapter 3. This is for purposes of the test. What you need to know that I'm not going to talk about is what are the grounds on which the party who loses in an arbitration can get a real court to overturn the arbitrator's decision or reward. What you're going to find out when you look that up in the textbook is there are very few reasons that a court will look at an arbitration arbitrator's decision and say, yeah, this is no good, I'm throwing it out. That is because arbitration is super, super, backed up by public policy. In other words, the federal statute that started all this arbitration stuff is called the Federal Arbitration Act, the FAA. Every one of the 50 states now has its own little state mini version of the FAA. And the FAA says, and there are hundreds of U.S. Supreme Court cases of arbitration, which say the decision of an arbitrator cannot be overturned by a judge except for these very, very limited reasons. Those statutes all say arbitration is heavily, strongly favored by the courts. Basically, if you sign an agreement, a contract, which says in it, hey, if anything goes wrong under this contract between me and you, we both agree we're not going to sue each other, we're going to go to arbitration. If the parties, if the court finds that that is a legitimate agreement, the parties entered into freely of their own free will, this arbitration agreement, and that the dispute between the parties is the kind of dispute that they agreed to arbitrate, it arose out of the contract, then the courts say, you go to arbitration. So here's what's been happening. There's no way out of it, okay? There really is almost no way out of arbitration. Arbitration tends to favor the big guys. So if it's an employee who believes she's been fired for discriminatory reasons, but she signed an agreement that if anything went wrong in her employment, she wouldn't sue her employer, she would go to arbitration. A lot of times when push comes to shove and the dispute with the employer arises, the employee who has agreed in writing to go to arbitration goes and finds a plaintiff's lawyer who says, we ain't going to arbitration, we're going to court. If they don't want to try the case, they can spend all their money and time fighting us in court. So I have probably handled personally like 40 such cases in the last 10 years, where people have signed arbitration agreements saying they will not sue my client, they will go to arbitration, but sure as hell, once the stuff hits the fan, they go find a plaintiff's lawyer who files a suit in court. Because the perception is, and there's a lot to back up this perception, that arbitrations and arbitrators are going to be more conservative lawyers, and they're going to favor the big boys. So the poor little employee who is having to sue Exxon for discrimination, Exxon's lawyers are way happy that they get to go to arbitration and not in front of a jury who might sympathize with this little employee and give her $1 gazillion, right? Arbitrators don't do that stuff. Arbitrators are usually lawyers trained in the law. They're not going to be affected by sympathy factors. They're not going to be affected by, all the kind of outside stuff that might come into play when a jury is making a decision. So the jury tends to side with the little guys. That's why the big bad boys like to be in arbitration, because they're going to get off more easily. Even if they get nailed, it's usually going to be for a lot less money than a jury might award. So the other party, in my case, I've done a lot of, we've had a lot of subcontractors go against our clients who are general contractors, where the subs want their money, they've agreed to arbitrate in their subcontract, but they go get a lawyer and the lawyer files a lawsuit instead. So then we have to come in and go, he can't sue us, he agreed to arbitration. All we have to prove to the judge is that there's a valid arbitration agreement, that is his signature on that arbitration agreement. Nobody held a gun to his head to make him sign it. Nobody forged his signature, that's his signature. And it says he's willing to arbitrate any issue that arises in the context of this construction project or any issue that arises The issue is, he wants to be paid under his subcontract with us. I'm home. Case dismissed, judge orders plaintiff, you can't come into court, you have to arbitrate this, okay? So, a lot of employers these days are kind of, forcing the big guys, the big corporations, have realized this over the last 10 years, and they know they make out better in arbitration than they do in front of juries. So, some of them have started requiring applicants for jobs to sign arbitration agreements. You want the job, you'll sign this arbitration agreement, saying that if you get into a dispute with us about your job, you can arbitrate, you're not gonna sue us. Well, if you're sitting there and you want the job, you're probably gonna sign the damn thing, right? And then 10 years later, when everything hits the fan, you're like, oh my God, I gotta arbitrate with these people. I'm not gonna win, right? So you go find a lawyer, and the lawyer goes, it's okay, we'll make them sweat it out for a while. I had one case, a construction project, it took us 3 years to get the arbitration proceeding rolling because the people the subcontractor that sued my client went and found lawyers who just don't really care what the law is or the facts are. They want to be in court in front of a jury. And so they just kept fighting it. The judge dismissed the case, told them to go to arbitration. What did they do? They appealed that decision. They lost there. They went to the Louisiana Supreme Court, appealed that decision. Supreme Court, all the courts go, you gotta arbitrate. No, they go back to the trial court and they try another method of getting out of arbitration. Then when they lose that, they go to the appeals court. When they lose that, they go to the Supreme Court. Cost my client like $700,000 just to get these people to go to arbitration. And as I said, perception is reality, right? And the little guys all think they're gonna get screwed in arbitration and the big guys are gonna win. So they fight it like crazy. Once you get to arbitration and you get an arbitrator award, you get the decision, you can then go to court and you can, if you're the winning party, you go to court and you ask the court to bless this arbitrator's award and make it a judgment. So you can now go collect your money, right? If you lose an arbitration, you can file, you have very limited time frame, but you can file a motion to vacate the award, that is, you're asking a real court to throw the award out altogether. Or you can ask them to modify the award, change it, judge. But when you look at your textbook, you will see you have to be able to prove to the judge, to the court, that the reason he should throw out the award or the reason he should modify it is one of the reasons in the very short list of reasons that the Federal Arbitration Act says a judge can throw an arbitrator's decision out. So the deck is heavily stacked in arbitration, and people are fighting it tooth and nail, but the courts, all the way from the U.S. Supreme Court down, say if you signed an arbitration agreement and the dispute between you and the other party is one of the kinds of disputes that you've agreed to arbitrate, you got no recourse. You cannot come to court, you must in fact go to arbitration. The other thing employers are doing these days, with existing employees, people who were hired before the company decided to try to get everybody to agree to arbitrate, they can't fire. They're not gonna go in and fire people after the fact, after they've been working there for 10 years, because they won't agree to sign an arbitration agreement. But they will say, if you don't agree to sign this arbitration agreement, you are not eligible for any promotions or any raises in the future. And the courts have upheld that. So it's kind of a nasty business. It's really fun to be on the bad guy side if you're arbitrating, because you know you're going to be arbitrating. I had another case. This case was filed March 23 of 2011. He went to court. We fought him. Judge told him to arbitrate. He had 230 clients. We decided to take the first proceed. Well, when they lost the first arbitration, their lawyer absolutely freaked out and went back to the court that had already kicked them out and tried to get it undone. When that didn't work, he went to federal court and filed two, not one, but two lawsuits against my client, again, trying to fight arbitration, on every ground imaginable. And here we are 5 years later, and I just filed last week what I hope to God is the last brief for the Louisiana Supreme Court saying, will you please tell this guy he can't be in court, he has to arbitrate. He has refused to do so, and he has put it in all the pleadings in all the cases he's filed. We ain't arbitrating anymore. And the judge goes, well, that's your call, Mr. Smith, but that's also your only remedy. You don't have to arbitrate. Are you forcing me to arbitration? No, I'm not forcing you to do anything. But I'm telling you, if you